Good morning. Today we are going to see the offense of giving false evidence. Okay, it is being mentioned in section 227. Giving false evidence. Whoever being legally bound by an oath or by an express provision of law to state the truth or being bound by the law to make a declaration upon any subject makes any statement which is false and which is either known or believed to be false or does not believe it to be true is said to give false evidence. Means when a person states a false statement, maybe before the court or maybe before any officer, he makes any declaration which is false. Now he knows it to be false, or which he either knows or believes to be false or does not believe to be true. These three things are being discussed here. If he believes the statement to be false, and which he either knows or believes to be false or does not believe to be true, and he is making that statement, then it will be called as giving false evidence. Whoever being bound by law on oath or by an express provision of law to state the truth or being bound by law to give a declaration relating to any subject matter, and if it is false, that is called as giving false evidence. Now here the word statement is being used. Here the word statement means either it can be written, either it can be otherwise, or it can be verbal also. Therefore verbal statement, oral statement, if it is false, which statement is being submitted as a part of evidence, then that will be called as giving false evidence. Section 227 is just defining the offense giving false evidence, and there are explanations which are like a statement is within the meaning of this section whether it is made verbally or otherwise. And explanation 2 states that a false statement as to the belief of the person attesting is within the meaning of this section. Means the executor, a document is being made, the person who signs, the person who executes the document is called as an executor, and the witnesses who are there who are called as attesting witness. Now the attesting witness, if he is also coming under this particular statement, this particular offense, a false statement as to the belief of the person attesting is within the meaning of this section, and a person may be guilty of giving false evidence by stating that he believes a thing which he does not believe, as well as by stating that he knows a thing which he does not know. Okay, now this is giving false evidence. Now section 228 clearly states about fabricating false evidence. 227 is telling giving false evidence. We'll take one illustration. A, being bound by an oath to state the truth, states that he believes a certain signature to be in the handwriting of Z, and he does not believe it to be the handwriting of Z. Here A states that which he knows to be false, and therefore it is false evidence. This illustration deals with attesting witness. Okay, now this is giving of a false evidence. Now fabricating of a false evidence. See, fabricating means what? Making, creating a circumstances in such a manner that people will think about that this is something true, but actually it is false. We'll take an example. I have stolen some jewelry, but in fear of that I may be catched, what I do, I put the jewelry in your purse, so that when the police officers who are there, who are searching everybody, when they will search your purse, they will have an impression, the persons who are there, they will have an impression that you have stolen the jewelry. This is called as fabricating of false evidence. Okay, that is mentioned in section 228. Fabricating false evidence. Whoever causes any circumstance to exist or makes any false entry in any book or record or electronic record, or makes any document or electronic record containing a false statement, intending that such circumstances, such false entry or false statement may appear in evidence in a judicial proceedings or in a proceeding taken by law before a public servant or before any arbitrator, and that such circumstance who in such proceedings is to form an opinion, means that concerned arbitrator or the judge, the person who is there to decide, may cause any person who is in such proceeding to form an opinion upon the evidence, to entertain an erroneous opinion touching any point material to the result of such proceeding, is called as fabricating false evidence. Means here I am creating circumstances in such a way that whenever the thing is being put before the officer, investigating officer, or to the court, they will have an opinion that you have stolen the jewelry. That is called as fabricating false evidence. Okay. Now section 229 states about punishment for false evidence. Now this section divides like, if false evidence is being submitted in the court, then punishment is different, and otherwise the punishment is different. Okay. Punishment for giving false evidence. Whoever intentionally gives false evidence in any stage of judicial proceeding or fabricates false evidence for the purpose of being used in the stage of judicial proceeding shall be punished with imprisonment of either description, which may extend to 7 years, and fine which may extend to 10,000 rupees. Means giving of false evidence or fabricating evidence which is submitted in a judicial proceeding at any stage of judicial proceeding, that will be punished under subsection 1 of section 229. Okay. Now the subsection 2 says, whoever intentionally gives or fabricates false evidence in any case other than referred in subsection 1 shall be punished with imprisonment extend to 3 years and fine which may extend to 5,000 rupees. So how the punishment is been divided? If the false evidence or fabricating evidence is submitted to the court, we can't say just court, it is a judicial proceeding, then punishment is in subsection 1, and in otherwise it is in subsection 2. Now what is the judicial proceedings? They have made explanation. A trial before a court martial is judicial proceeding. An investigation directed by law preliminary to a proceeding before the court is also a judicial proceedings, though that investigation does not take place in the court, but it will be used in the court, therefore it will be called as a judicial proceedings. We'll take an example. A, in an inquiry before a magistrate for the purposes of ascertaining whether Z ought to be committed for trial, makes an oath, a statement which he knows to be false, as this inquiry is a stage of judicial proceeding. A has given false evidence. An investigation directed by a court according to law and conducted under the authority of the court is also called as a judicial proceeding, though the investigation may not take place before the court. Okay. Now means the division of punishment takes place as in the judicial proceeding or otherwise. Okay. Now section 227 is explaining to us giving false evidence. Section 228 states about fabricating of false evidence, and 229 is providing for punishment for giving false evidence and fabricating evidence. Okay. Now section 230, giving or fabricating false evidence with intent to procure conviction of capital offense. Capital offense means where the punishment is death penalty. Okay. Whoever gives or fabricates false evidence intending thereby to cause that any person to be convicted by a capital punishment, then he will be liable for imprisonment for life or imprisonment 10 years and fine 50,000 rupees. Okay. Now subsection 2 is telling that here just false evidence has been given or evidence has been fabricated in a matter, in a case where the offense is punished by death penalty. Okay. Now just it is mentioned like nothing has happened further in this subsection 1. 2 states that because of submitting false evidence and fabricating false evidence, innocent is being convicted and the death penalty is being executed. Means subsection 1 is telling about giving false evidence in a case. It is not telling that maybe the person has been hanged by neck till death or not, whether penalty is being executed or not. They are not mentioning that. Subsection 2 is telling that if an innocent person be convicted and executed in consequence of false evidence referred in subsection 1, the person who gives such false evidence shall be punished either with death or punishment which is mentioned in subsection 1, that is life imprisonment or 10 years imprisonment and fine 50,000 rupees. We'll see again section 230. 230 is telling giving or fabricating false evidence with intent to procure conviction of a capital offense. Got it? Means when a person is giving evidence, false evidence in such a matter, we'll take an example like a charge of murder is there, and the person clearly knows that this offender who is being charged is this accused who is being charged has not done the offense, but he is giving false evidence with an intention that he should be convicted. Then if it is been brought further, then he will be liable under subsection 1. But if it does not come further, the poor accused is convicted for death penalty and the death penalty is being executed, and afterwards it is found that he was innocent and this person has given false evidence, then he will be liable under subsection 2 and the punishment is severe. That is, death is also there, death penalty is also there, because an innocent person is being executed with death penalty because of his false evidence. Okay, bye bye. See you in the next video.